Please bow as I offer an invocation. Lord, we thank you for this day that you've given us to serve you and to do your will. We thank you for the strength, the energy, and the ability to do the things you've called us to. We pray for your wisdom and guidance as we continue to do your will and the will of the people you sent us here to represent. In Christ's name I pray. Amen. Amen. First on the agenda is going to be House Bill 973, and I am the sponsor of that bill. So I'm going to come down and present for the committee the bill, and also for your planning purposes, we do not plan to call any other bills for a vote today. House Bill 973 will be the only bill we vote on today. And we don't plan to call any other bills for a hearing today either, just to be clear.
This is it.
This is it. So, Valerie, would you?
Welcome, Mr. Chairman.
Thank you, Madam Chair. I'm here to present House Bill 973. I'm looking at LC 391351S, LC 391351S, and this is a bill that really was requested by a constituent of mine who is in the towing industry and had some concerns about the safety of towers on the interstate and the safety concerns that he had observed and the issues that I'm sure many of us have been driving down the road on the interstate and cringed to see people sort of pulled over and trying to be dealt with an emergency situation and heavy traffic. And so what I learned through the process is that many of our larger towers are already doing a significant amount of training annually or on another rotation, and this bill would simply require folks who want to do towing on the interstate to get a permit from the Commissioner of Public Safety. And in order to get the permit, they have to certify, or they have to demonstrate to the commissioner that they have satisfied the minimum safety training requirements that have been recognized by the Towing and Recovery Association. And so the commissioner of DPS would administer the program. I had a preliminary cost estimate from the Department of Audits and Accounts, and it was on a previous version of the bill, so it's not exactly accurate, but the likely cost under a previous version that actually would have cost more than what we've done here was about $60,000 a year in continuing costs for the agency. And to cover that cost, we've included an $85 fee for the permit that towers would have to pay to the department. The bill also provides for civil penalties for violations, and it provides for an appeal process if someone is denied a permit or if their permit is withdrawn for any reason by the commissioner. So that's the bill.
Ladies and gentlemen of this committee, do we have questions? Is it Mr. Nimmer? Floor Leader Nimmer? Oh, I'm sorry. Is it Mr. It's Representative Diffenbaugh.
Thank you, Madam Chair. And am I on or not?
You are now.
I am now. I am? Okay.
Turn.
Hear it. Now try. Still not? No?
I can hear you.
Loud.
We'll put your volume on.
I can just repeat your question into the microphone.
Okay. The question I had right off, Representative Chairman, is this $85 fee, is that for every person that's going to be on the road, or is it one for the company and then they can all do it?
It's for any tow operator. It's a tow service provider, which is defined in line 24 and 25. Any person who is utilizing a vehicle to tow a disabled, damaged, abandoned, or wrecked vehicle in exchange for a fee. So it's any tow truck operator It's not the towing company. It's the individual operator who has to get the permit to do that. And again, it's only for, I don't know if I said this earlier, but it's only for towing on the interstates. It's not on the county and state roads.
If a company has 6 people that do towing, they'd have to have 6 licenses or 6 permits?
Well, they'd have to have a permit for any of those folks who want to tow on the interstate.
On the interstate. Okay, thank you.
So, and it may be in a rural community that's not near an interstate, they may be able to suffice by having one person with a permit to tow on the interstate if they get a call to go pick up somebody who's, out of town and they need their car towed back home or something.
Thank you.
Thank you, Mr. Diffenbaugh. Chairman Sims.
Thank you, Madam Chair. At the appropriate time, I'd like to make a motion to approve.
We have 2 more questions at this time. And Madam Representative?
Thank you very much, Madam Chair Lady. This is only if they're charging a fee, right?
Right.
So an individual that was trying to get something off the road, though we think it may be a little dangerous, would not be required to comply with this.
Right. If somebody calls you and says, hey, I'm broke down on the side of the road, can you come pull me home? If you're not getting paid for it, you don't have to have a fee. I mean, a permit.
Well, I applaud your efforts to make sure they're adequately trained. Thank you.
Thank you.
And thank you. Chairman McCall.
Thank you, Madam Chairman. Chairman Coombe, I did show up for your bill today.
Appreciate it. I think.
I'm for it. This really doesn't have anything to do with this bill, but it does have something to do with the bill. I had a constituent who owns a bus company call me a while back, and he owns his own wrecker. When his buses break down and he goes wherever he's got to go and picks them up, and they go across a scale, the back axles on a 10-wheeler wrecker are too heavy. And I noticed, have we done anything to address that, or did your guy happen to say anything about that?
Yeah, that's a good question. And in fact, a previous version of this bill actually dealt with replacement vehicles being towed that were overweight replacement vehicles. And what we did through the process of discussing it with DPS and the Department of Transportation is those agencies have resolved the inconsistency that had existed. So now if a tower is towing a replacement vehicle, an emergency replacement vehicle, to the side of a broken down overweight vehicle, then they only have to have one permit to do that, and that they're covered now. They're not going to get cited coming and going for being overweight. Is that the issue you're talking about?
Yeah, pretty much. Pretty much. Every time they'd go across a scale or get stopped somewhere, the back axle on the wrecker would be too heavy.
We were ready to include that and included that in a previous version, but the commissioners of the 2 agencies got together and in their wisdom resolved it without the need for legislation.
That's real good.
Yeah. Thank you.
Thank you, Chairman McCall. Are there any guests who have signed up to speak? I guess.
I'd like to speak. I didn't see a sign-in sheet.
Well, very good. Welcome. Okay. Sir, would you like to speak first, introduce yourself, and welcome. We're so glad to have you speak today.
Thank you. So on behalf of the Department of Public Safety, I'm Major Johnny Jones, Motor Carrier Compliance Division Commander. And first off, we'd just like to say that this, of course, is not department legislation. We will enforce whatever laws that's passed by the General Assembly. But we do have some concerns on this bill. One of the concerns, and I don't have a current version of the bill, so I'm going off a previous version, yesterday's version, is that the definition of a towing service provider changed from one bill to another. So we need to know basically who we're going to enforce the law on and who has the permit. Typically, when you issue a permit to a motor carrier, it's issued to the carrier. And the motor carrier then has one permit. The way we're reading this, it would be issued to the tow truck driver. The difference in the definition from the previous version to this version. The other thing that we have a concern about is whether or not it is an annual permit or it is a perpetual permit. For non-consensual towing permits that we issue now, it is an annual permit. For passenger carrier permits that the agency issues, it's basically a perpetual one. You pay a fee of $75 and you never have to pay it again unless it is canceled or revoked. So we'd like that to be clarified. The other thing that we have is in regard to the safety training. We would like to see the language read a bit differently. In regard to, it says the applicants must meet or exceed the minimum safety training standards recognized and approved by the Commissioner of DPS, rather than a private party having that the Commissioner could recognize whoever provided those training standards, whether it was TRAG or another association or a private individual, or if the department at some time or another, which we have done, decided that we could provide that training as well. So we'd like to see that change to be that the Commissioner would authorize whatever types of safety training instead of having a third party do it. For enforcement purposes, if you look in the law, the way it's, or look in the legislation the way that it's written, it says it is a civil penalty. And also in the legislation, it says that the tow truck provider, tow truck driver, has to have a copy of that permit. But it's unenforceable on the roadside if it's a civil penalty. The deputy sheriff that stops that record driver loading a car on the interstate, the state trooper, one of our officers, we can't enforce it roadside. So we ask that that be looked at. And other passenger, well, in our passenger permits that we issue, it is a misdemeanor if they don't possess it. And it is enforceable roadside just like a traffic violation, which this would be. The deputy would have to notify us that such an infraction has occurred, and then we would have to take action on top of that. That certainly would tie up our legal team in doing civil penalties on that. Next thing is the permit holder is allowed to continue in operation after the Commissioner of Public Safety has denied or canceled the permit. That is a concern. If that is a safety cancellation, for example, that motor carrier has demonstrated unsafe operations and the Commissioner cancels that permit, it means that he can continue to operate unsafely until a hearing. That's not the way we have done business in the past, is that they get a hearing after the cancellation is made and appeal that decision. But it doesn't change the fact that they cannot continue to operate. The cost of the permit, as mentioned, was $85. And my understanding is that if it is not listed in the law, silent as to where those proceeds of those fees go, that it goes to the General Treasury rather than the department. And that's something that I'm sure in your infinite wisdom you know. But that's a concern as well, is that we have taken on a lot of regulatory functions in the past that has taken up a lot of time and resources, and our budgets remain the same.
Thank you so much for your comments, and Chairman Coomer has some answers for you, I'm sure.
Sure. Let me just say I appreciate the Commissioner's work on this bill. He and I have talked repeatedly from early in this session, and I know he's out of town today and couldn't be here, or he would be here himself. And as to the comment about the money going into the general fund, that is correct, and we discussed that early on. But of course, if you look at line 26, the entire bill is subject to appropriation by the General Assembly. So we're not asking the agency to take on additional work that it can't do, or take on additional responsibility without being adequately funded for that. So I think that becomes a moot point when we make the entire provision subject to appropriation. And regarding the civil penalty provision, I know this committee has heard testimony even earlier this year that it's a common practice in some industries that are regulated by the department to deal with violations through a civil penalty process. And so that's what we were trying to do is mirror what happens with other industries that operate subject to the approval and regulation of the department. I'm not opposed to making it a misdemeanor. Frankly, I felt like it was a cleaner bill if we did it as a civil penalty. I think that's probably it's probably a more efficient way to do it as a civil penalty as opposed to a criminal misdemeanor charge, because with a criminal misdemeanor charge, you're going to have your troopers off the road and in court at times that they don't really have any control over in the various county courts. So I felt like this would be a better way to let the commissioner regulate it than requiring it to be through the criminal process. As far as the appeals portion in lines 62 through 74, I'm certainly open to any suggestions for changes in that regard, and I'm happy to entertain any kind of amendment you may want to make to that. I think I addressed all the issues raised.
Thank you, Mr. Chairman. We have a comment or a question from Representative Gardner.
I was curious about the training, and I found on line 34 that there is a training program, some kind of a certified towing and Recovery Association of Georgia has adopted specific training.
I've heard that.
Let me, Madam Chair, if I can address that. Sorry about that. What we did not want to do was put the commissioner in the position of having to come up with an entirely new training program, because the industry has training programs available already through private providers. So what we say is that the commissioner just has to be satisfied that the operator has had the minimum safety training requirements that are accepted as the industry standard, and that is the standards that are adopted by and recognized by the Towing and Recovery Association of Georgia, in effect as of February 21st, 2016. I got a copy of it just this afternoon, and I'm happy to pass around what they are, but the standards are general in nature and designed so that a private provider can come in and create a program to train to these standards. And then it would be incumbent on the commissioner to review what those training options are and approve trainers or approve programs that people could then go out and do on their own. And my understanding, and I've had extensive discussion with the towing and recovery industry folks, my understanding from them is again, as I said earlier, most of the bigger carriers are doing this training already, and they're requiring the training of their drivers. This is to make sure that everybody is doing that on the interstates.
Well, as a former association executive, I would think it would be a nice function for the association to provide the training. Did you clarify the question about whether each individual driver?
I did not, but I will. The intent of the bill is that each individual operator, each driver, would have to have this training, not that each company would have the training, but that's only a driver who's going to operate on the interstate. So if you have drivers, you may have some drivers who aren't going to be interstate drivers, and they wouldn't have to have the training.
Floor Leader Nimmer.
Yes, ma'am. Thank you, Madam Chair. Chairman Coomer, what part, and I apologize for not catching it, did you say you were open to changes?
Well, I'm open to any changes that you think will make the bill better, but specifically I said lines 62 through 74 regarding the appeals process for towers who are suspended or revoked by the commissioner.
Okay. Thank you for clearing that up.
And while we're talking about amendments, if I may, I did see, I have noticed, and I want to say thank you, Jenna, for helping with this. Jenna Dolde from Legislative Council, we have gone through, I don't know, I've lost count of how many iterations we've gone through, but as I'm sitting here, I did find one area where I had overlooked a change. We had made a change to one part of the bill and we didn't make it in another part, and that's on line 28. It says, which allow towing service providers to respond at the request of law enforcement to any. And what I'm going to do at the appropriate time, as we're handling the final version, I'm going to offer an amendment to strike the words "at the request of law enforcement" and insert the words "to disable, damaged, abandoned, or wrecked vehicles," to clarify that that it's a responding to any of those classes of vehicles, not just responding at the request of law enforcement. And also, I thought we had clarified this in a previous version, but I don't see it now. But I would like to add on line 31, I'm going to add the word annual. I'm going to offer an amendment to add the word annual before the word permits, to clarify that these would be annually issued permits, which was another issue that Major Jones brought up that needed to clarify.
Is there any more conversation from our committee? We have one more guest,
I have one question.
Mr. Diffenbaugh.
I guess my mic is still not working.
We'll
so
try to get it.
try again. It's working. Thank you. I appreciate all this input, but for clarification for annual reports, should there be a date or something that would say what time it is, or is it going to be based on each time they pass? We're going to be doing this daily?
I'm open to any suggestion you have to clarify it. I would think that if the bill becomes effective July 1st, then towers are going to need to have that permit in place on July 1st, and then annually they'll have to renew it by July 1st of the following year.
Okay, that sounds clear. Thank you.
Thank you so much, committee members, for your conversation, and thank you so much for your wisdom and for being here today. We have one more guest to speak.
Good afternoon, Justin Kernan with the Georgia Municipal Association, and thank you for giving me an opportunity to speak on this bill. And we feel that House Bill 973 is a good bill. I don't have the latest iteration of the bill, but I spoke with the chairman and the author of the bill regarding a few suggested points of clarity as it relates to local governments. And our only concern with this bill is wanted to make sure that nothing in this bill would exempt local governments from the regulatory authority that we have on local government roads. So our suggested language is, and I don't know exactly where this would go in the substitute, but there was a portion that says provided, however, that any such permit in addition and not in lieu of the ability of counties, municipalities, or consolidated governments to regulate towing services providers operating on any portion of state or local roads or jurisdictions. So we think, I don't know exactly where we would plug that in.
I think that would be on line 30,
okay,
at the end of the sentence, after the word permit.
Okay. And we would just like to make sure that we can still control things on our roads. And another friendly suggestion, on the previous copy of the bill, it was on lines 33 through 36, and we just suggest a rearrangement of the paragraph so it reads every such permit. And because what it currently says is that law enforcement agencies can be given enforcement authority to the commissioner, by the commissioner, and we wanted to rearrange the paragraph a little bit so it reads, every such permit and other documentation required to the commissioner shall be carried in the vehicle to which it refers, and shall be open to inspection by any employee of the department who has been given enforcement authority by the commissioner, or to any law enforcement officer acting within the scope of his or her authority, just to make sure that local governments sometimes, stop or provide these stops on the interstate as well, and we want to be able to ask for those permits also.
On that point, let me say, in reading this language, comparing it to the current language at lines 43 through 46, there's one problem with the suggested language, and that is that it refers to documentation to be carried in the vehicle to which it refers.
Yes.
And our bill actually doesn't, current version of the bill does not require a permit for the vehicle. It's a permit for the operator.
Okay, then.
So looking back again at the language that we have, it says a copy of the permit and all other documentation required by the commissioner shall be carried by the towing service provider and shall be open to inspection by any law enforcement officer or employee of the department who's been given enforcement authority by the commissioner. So I'm not sure. So I guess in order to effectuate your concern, we could just add to that the words, or to any law enforcement officer acting within the scope of his or her authority. That would cover your local concern?
Yes, it would.
Okay.
Yes, it would. Thank you very much for being open to those suggestions.
Thank you so much. And Mr. Chairman, you have 3 amendments proposed, and you're in favor of all of those amendments. Is that correct?
Yes, I am. Okay. And when you're ready for me, I'll be glad to walk through them again to make sure we're all on the same page.
Okay, please, let's do that. Let's take Amendment 1 first of all, and that was on lines 62, I believe, beginning on line 62.
Well, I didn't have an amendment there, but if anybody wants to amend that language, I'm open to that.
I think we have enough, so we'll go ahead with the ones that you have.
Okay. The first one I would have would be at line 28, striking the words "at the request of law enforcement" and inserting the words in their place, "to disabled, damaged, abandoned, or wrecked vehicles." So the line will read, "which allow towing service providers to respond to disabled, damaged, abandoned, or wrecked vehicles on any."
And the second?
Hold on.
Can I suggest that instead of that language to put to operate on any portion, because the definition includes disabled, all that language.
Okay. So just the strike would then begin with the word respond at the request of law enforcement, and then insert the word "to operate," or "operate" would be the insertion. Is that correct? Okay. Sounds great to me. The second, do you want me to go on to the next one?
Please do.
The second one would be at line 31, inserting the word "annual" before the word "permits," so that the line reads, "pursuant to the code section, annual permits shall be issued to towing service provider applicants."
Very good. And the third?
The third would be on line 46, adding, I'm sorry, actually there would be 4, because the third one would be at line 30, the language offered by the witness that would, on line 30, it would, before the period, you'd have a semicolon, "provided, however, that any such permit is in addition to and not in lieu of the ability of counties, municipalities, or consolidated governments to regulate towing service providers operating on any portion of state or local roads within such jurisdiction."
And then the fourth is on line 46?
Yes, ma'am. And it would be before the period after the word "commissioner," we'd insert the words "or to any law enforcement officer acting within the scope of his or her authority."
Very good. At this time, do I have a motion on the bill itself?
I make a motion.
Thank you, Mr. Floor Leader. And we have 2 seconds. Thank you very much. And let's look at our amendments. Line 21, respond at the request of law enforcement. Motion to accept.
Madam Chair, I think if you want to just ask if there's an objection to each of those
Okay,
amendments,
I will.
then if
Is
there's
there
no
a-
objection, it can be adopted.
Is there any objection? All right, and line 30, semicolon, provided, any objection? 31, insert annual permits, that's annual permits. And then 46, any objections to line 46? Very good. All right, and then we will vote 28, we did, that was respond at the request of law enforcement. Yes.
I think, Madam Chair, you might have said 21 when you meant 28.
I'm so sorry, that was 28. 28.
Which was striking the word respond at the request of law enforcement and adding the word operate.
Operate, very good. Okay. At this time, we have number 17.
Yes, ma'am. Madam Chair, before we move on the bill as amended, just a point of clarification for me, and I may want to direct this through if it's okay to Chairman Coomer. So we're going to pass the bill with the 4 amendments with the understanding that there'll be another substitute drafted for us to have in rules. Is that correct?
Yes. What will happen is council will draft a committee substitute, and once that committee substitute comes back, we'll sign off on it and submit it to rules as the committee is now amending it.
Okay.
Just the substitute.
Just trying to keep myself clear. I actually had a couple constituents call about this one, and they're watching it close, and I want to be able to correspond back to them properly. And so if
there's nothing in here about one-legged drivers.
That was a real call, by the way. You just need to come live in my office for a little while. But if he's watching by internet today, I'm going to give him your phone number, by the way, Chairman Coomer. But
I wanted him to know you cared about his issues.
The MCCD and Georgia State Patrol and all the stakeholders involved in this, if we pass this with the 4 amendments with the understanding that the substitute will be in rules, and there's something else clerical or whatever, it can be amended between now after we vote it out. And I know we got a calendar we're dealing with and everything else, but there's still that opportunity to tweak it in rules. Is that correct before it goes to the floor?
That is correct, and I'm glad you brought that up. If you have another question, I'll answer it before I go on.
Yeah, I think that's it. It can further be amended after it leaves here today before it comes to the floor if there's further concerns from anybody in the room.
That's true. And I'll be open to further discussions, as it goes into rules, as it sits in rules. If anybody wants to come and make other suggestions, I'm certainly open to discussing how to make it better, even after the committee's done.
Madam Chair must be done with me. She turned me off there.
No, Mr. Nimmer, I assumed you were finished. I'm so sorry. Do you have another comment?
Madam.
Have another comment?
No, ma'am.
All right. Very good.
I do have one other, and I apologize. I've looked back in my notes at one other thing that I had agreed in going through the negotiation process with the interested parties. I had agreed to include a sunset provision in this bill, a 4-year sunset provision, so that the bill would sunset unless renewed by the General Assembly. The bill would sunset on January 1st, 2021.
Are there any questions about the sunset inclusion, the amendment? At this time, we have...
I think, Madam Chair, I think Mr. Nimmer had a
I'm a
question.
little button happy. I'm sorry. Why would we sunset it?
Well, because the folks who had real buy-in to the bill wanted an opportunity to come back and review it and see if the bill was working the way it was supposed to work. And I in good faith, dealing with them, I said I'm not opposed to having an opportunity to come back and review it in 4 years for whoever may be still sitting in this committee.
Thank you, sir.
We have a motion. We have a second. Any more discussion?
Madam Chair, would you just clarify that, ask if there's any objection to the sunset provision?
Is there any objection to the sunset?
Thank you.
Oh, you're welcome. A motion, a second. At this time, all in favor say aye.
Aye.
And it passes. The substitute to House Bill 973.
Thank you. You want to adjourn us?
And at this time, we will adjourn.